Professor Patricia Popelier, welcome to our seminar, the second seminar of the Constitutional Observatoire Project. We are very glad with your acceptance to participate of our seminar. It's a joy. Professora Patrícia Popelier, professora titular da Universidade de Antuérpia, na Bélgica, titular catedrática do Constitucional da Bélgica, e falará sobre o tema Subnational Constitutions in a Dynamic Theory of Federalism, ou seja, constitucionalismo subnacional em uma teoria dinâmica do federalismo. Professor, thank you very much.
Thank you. Thank you for inviting me and for organizing this seminar on subnational constitutions. It is a topic that in traditional federal systems and in traditional federal theory is considered a matter of course, perhaps not always very interesting, but self-evident. Every so-called mature federal system should have it. Now, in reality, this is not the case, and especially in some contemporary multinational federal systems, it is even a bone of contention. My own country, Belgium, is an example of that. There is a demand for it by a certain group, but it's not self-evident at all. So this topic gives me the opportunity to discuss the need for a renewed theory of federalism, which I call dynamic federalism. And I will go about as follows. First, I will define subnational constitutions and then explain that subnational constitutions are not a defining feature of federations as traditional federal theory would have it. Instead, they are an indicator of subnational autonomy in a theory of dynamic federalism. And dynamic federalism is all about the weighing of autonomy and cohesion. And so we need indexes to measure autonomy and cohesion and apply that to subnational constitutions. So I will do that, and then I will conclude and give some prospects for future research. So first, what are subnational constitutions? And for that, we first have to know what national constitutions are. And there are two aspects to it. One of content, meaning that national constitutions usually have four components. They describe the fundamental identifying marks of the state, and then the organization of public authority, representative structures, and then relations with the executive. Third, the relations of public bodies with individuals. These are the fundamental rights. And then some basic policy principles that bind the authorities. And then these constitutions have a procedural side to it. Usually they are a bit entrenched because they are the product of a sovereign people. They are adopted, revised, and amended by the people of the nation. Now, for subnational constitutions, we can take that as a starting point, but subnational constitutions are more limited, and that's because they are part of that constitutional system, that nation. And so they may comprise, as to content, they may comprise these 4 or 5 components, but not necessarily so. So they can be strong or weak, depending on whether they address all these topics or not. And as for procedure, well, constitutions are frameworks for self-governance issued by the subnational people, but they're always part of the larger federal system, which means that the federal government sometimes interferes in the adoption procedure. And at a minimum, we can expect that a subnational entity at least have some say, so that they have some ownership over that constitution. But again, the power to adopt subnational constitutions can be strong or weak, depending on whether the federal level will intervene. And this brings us to the following definition. Subnational constitutions are basic documents for subnational entities that lay down entrenched basic rules on subnational identity, representative structures and the organization of powers, fundamental rights, and policy principles, and they require the approval of the people or the representatives of the people of the subnational entity. That brings us to the second part, and that is a criticism of old federal theory that sees subnational constitutions as inherent to federal systems. Now, in traditional federal theory, distinction is made between three types of forms of state: unitary states, federal states, and confederations. And they all have their own set of institutional features, and these institutional features are defining features, which means that a system has to have them to be called that, to be called a unitary state or a federal state or a confederation. Now, scholars do not always agree on the precise set of criteria, but as for federal systems, constitutional or subnational constitutions are often part of this. Any genuine federal system has substates with their own subnational constitution. Now, I argue against this contention for three reasons: a theoretical argument, a comparative reason, and a fundamental reason. So the first is theoretical. The idea that substates have their own subnational constitutions is linked with the concept of sovereignty. There is a whole literature on who is the sovereign in a federal system. Is it both levels, the federal level and the federated states, that have their own sovereignty? That's usually the idea of dual sovereignty, or is it shared? And having sovereignty means that you can have your own constitution that is linked with each other. Now, and it's used to distinguish federal systems from, for example, administrative decentralization. But nowadays, the concept of sovereignty as a paradigm for federal theory has faded because there are too many problems attached to it. Sovereignty in itself actually means an undivisible, impossible to divide power, which is something that is just not compatible with the idea of federalism. The second is the comparative argument. The argument is that from a comparative perspective, all genuine or mature federal systems have subnational constitutions. And then traditional federal theory selects model federations, examines their institutional design, and on the basis of that decides which institutional features are essential for any federation. And essentially, the United States has left its mark here. But some other classic federations are referred to as well, Germany, for instance. And they are the mature, the superior, genuine models of federalism. And those systems that are not exactly like it have no value in themselves. They are aspiring to become a federal system like the model ones. That's the whole idea. Now, when we look at these model federations, they all have the same features. They are coming together federations. They are homogeneous, sometimes multicultural, but never multinational. They have a history of unification of formerly independent states or colonies. They might, they're mononational, so no significant group claims autonomy for identitarian reasons. And they're organized in a symmetrical way. These characteristics then do not show us how to design a federal state. They show us how to copy a particular federal state, how to become the United States, as it were. And even more, they show us how to design a particular state at a particular moment. If we, for example, look at Weir's definition of a federal system based on the original dual US system, even the US today does not correspond to that model anymore. So this is not very helpful to understand the dynamics of a federal system. If we examine more contemporary models of multi-tiered systems, it's just not going to fit. For example, if we look at Spain or Belgium or Nigeria, if we broaden our comparative view, what we see is that not all federal systems have full-fledged subnational constitutions. Look at Belgium, look at Canada, look at India. Much depends on whether they are coming together federations with subnational constitutions that already existed, or whether they are falling apart federations, where having a subnational constitution is just part of the federal bargain. For example, in Belgium, substates only have the power to decide some aspects of how their institutions are organized in a very fragmented way. And in Spain, the statutes are actually adopted by the central level. And this brings us to the third fundamental argument. Traditional federal theory is just not able to give us some insight in the dynamics of contemporary federalism. It doesn't grasp reality anymore. It's not able to grasp the challenges or to respond to the challenges of, in particular, multinational federal systems. So holding that any federal system should have subnational constitutions is very random. It just depends on which systems are selected as model federations. So what else can we offer? That brings us to the third part, and that is the part about dynamic federalism. So we notice that some federal systems have subnational constitutions, but other systems that also consider themselves federal do not, or do not have very strong ones, and that's okay. One federal system may fall short on subnational autonomy, but may give more autonomy on another indicator, and vice versa. For example, in Belgium, the subnational entities only have very weak powers to adopt their own constitutions, but on the other hand, they have very strong powers to conclude international treaties, stronger than any other federal substate in the world. My point is that institutional features are not defining features of federal systems. Instead, they are indicators. And not only for autonomy, federal theory often concentrates on how autonomous national entities really are, but that's not the whole thing. The essence of federalism, the core that remains throughout the wide variety of concepts and definitions over time, is that it seeks a balance between demands for autonomy of territorial subunits on the one hand, and the need for integrity or cohesion at the level of the entire system. Now, what the ideal balance is between cohesion and autonomy is different for every system. It depends on the purpose of federalism. It depends on some particular circumstances. For example, some systems are very insistent on securing the integrity of the system. They like to score high on cohesion and low on autonomy. Spain, for example, Italy, the UK, but also South Africa, Nigeria. Other systems are not so much interested in cohesion, but they are focused mainly on subnational autonomy. Examples are Belgium, but also Bosnia and Herzegovina. Germany would be somewhere in the middle. But these are just hunches. We only know where a system stands and where it is situated compared to other systems in a wide range from unitary, decentralized, regionalized, federal, confederal systems. If we measure, we have to measure how strong or weak a system scores on all the indicators together for both autonomy and cohesion. It's a project that I'm working on, but at the moment we are concentrated on subnational constitutions, and this is one of the indicators. So we're going to see how to measure autonomy and cohesion for subnational constitutions. Here's a proposal for an index. First, measuring autonomy. And I refer to the definition that I gave of subnational constitutions, which contained two measures, one for content or scope and one for procedure. So the index measures the constitutional space that subnational entities have to organize themselves, not what use they make of it. So they might have the power to adopt subnational constitutions. For example, the South African entities have some power to do that, not very wide, but they have some power to do that, and they don't make use of it. There's just one example in the West Cape who makes use of it, but the others don't. That's not what I'm testing. What I'm testing here is the institutional setup. What is the potential, what is the space that is provided to adopt the Constitution? So for content, the indicators refer to the definition of subnational constitutions with the several categories of constitutional matters: identity clauses, representative structures and organization of powers, fundamental rights, and policy principles. And so autonomy is strong. For example, the system in yellow is a strong one because their subnational entities can make substantial provisions for all of these aspects of substantive constitution making. But others, like the gray one and especially the dark blue one, they can only act in some or in none or in a very non-substantial way or in a fragmentary way. So there are differences. For example, in the US, states have the residuary competence to adopt and revise constitutions, limited only by the Republican Guarantee Clause. And by contrast, in Belgium, the entities are only allowed to make constitutional provisions for a limited number of issues related to elections, the parliament, and the executive. And this under very specific conditions and limitations. Further, procedural power is at its strongest where subnational entities can take the initiative and adopt the constitution with little or no involvement of central authorities, as is the case in the USA, and it is weak when external authorities have, for example, to give pre-approval, and so they can have a veto right. And then distinction is made between discretionary veto powers and judicial oversight. Judicial oversight is less intrusive because it will only hinder a subnational constitutional provision to come into force on the basis of legal arguments. For example, in South Africa, provinces must send their constitution or constitutional amendments to the Constitutional Court for certification, and the court will then examine whether the text was adopted in conformity with the central constitution. The index only takes into account judicial oversight by a central judicial body. If judicial review is exercised by a subnational constitutional court, and this forms part of the entity's own constitutional autonomy, so that doesn't count. So this is how we can measure and compare the power to adopt subnational constitutions. So for content, the question is whether the entities have any subnational autonomy, whether they can make arrangements in some or all of the 5 categories, and whether these arrangements are substantial or not. And for the procedural aspect, it's all about in what way can the central level interfere. For example, the United States would have the maximum score for content. The states can make substantial arrangements in all of the 5 categories, so that's a score of 5. And for procedure, they can adopt it without central interference by central authority, so that's a maximum score of 4. Together, that's 9. If we bring this back to a value between 0 and 1, they have the maximum value of 1. If you look at Belgium, you would have a score of 4. As to content, the sub-states can make non-substantial arrangements in some of the 5 categories, so that is 1. But within this limited scope, they can adopt their own constitution without central interference, but they cannot choose how to do that. The procedure is designed at the central level. So that's a score of 3. 4 together, which brings us to a value of 0.4 compared to 1 in the US. So that gives an indication of how they position, how they are positioned in relation to each other. And this is when we look at a certain state. Now, for the United States, it's the same thing for all the states because it's symmetrical. But a lot of federal systems or federal-like systems are not symmetric. For example, in Belgium now, it's all the same, but until recently, until 2014, two sub-states, the German-speaking community and the Brussels region, had no constitutional power at all. So until then, for them, the score would have been 0. So in this way, the index also allows to measure constitutional asymmetry within one federal system. That's for measuring autonomy. The other thing is, how can we measure cohesion? And to measure cohesion, we are concerned with uniformity or homogeneity clauses. And these are clauses that require compliance with central constitutional provisions and principles that are deemed essential for the integrity or the identity of the entire system. So we are interested in these clauses and also in the mechanisms, political or judicial, that control compliance before or after they take effect. This dimension is not about which system puts subnational constitutions in the most restrictive harness. Cohesion is not the opposite of autonomy, it's something different. Instead, the homogeneity clauses have the purpose of fostering a coordinate relationship between the federation and the subnational entities. And so the cohesion perspective is not so much concerned with the details, the detailed provisions which subnational constitutions need to adopt or from which they may deviate. It's more interested in the basic values and principles that underpin the political system. And that would be undermined if territorial subunits relished other principles. So where the autonomy index assessed subnational constitutional space, the cohesion index assesses the value of homogeneity. And then examples of homogeneity clauses are numerous. The US Constitution requires a republican form of government, which is not further specified, but seems to come down to a type of representative governance. In Argentina, the Constitution imposes a republican representative form of governance, which is about the same thing. The Ethiopian Constitution goes a bit further, where it requires subnational constitutions to advance self-government and a democratic order based on the rule of law. The South African one is even more detailed, talks about human dignity, human rights, constitutionalism, rule of law, cooperative government, etc. And then the German also refers to not only the republican, but also democratic and social state and the rule of law. So there's a difference. Cohesion is least protected if there is no homogeneity clause at all, or when compliance with such clause is not secured. For example, both the US Supreme Court and Congress have cleared away from enforcing the guarantee clause for Republican governments. They don't want to get involved in that. It is best protected where a homogeneity clause is present and enforced through an automatic and binding ex ante check. And then you have everything in between. The index does not distinguish between political and judicial control. What counts is whether the outcome is binding. And binding also means that political intervention by the government to secure homogeneity is considered valid. For example, the Argentine Constitution allows the federal government to intervene in the territory of the provinces to guarantee the republican form of government. An automatic check means that no clause can escape control, and therefore it's more cohesive than control upon request or control under certain circumstances. For example, in South Africa, as I already said, all subnational constitutions and amendments need a constitutional court certification before they can take effect. So that's an ex ante control, which avoids that clauses that potentially undermine cohesion take effect. So this brings us to this index, and here the US would score 1. There is a homogeneity clause, but there is no real or no binding compliance check. And South Africa would have the maximum score of 5, and Belgium would score 0. There is no homogeneity clause. There, the discretion to decide on the organization of their own institutions is so limited, so low, that no homogeneity clause is needed. But this also means that the values that underpin both national and subnational constitutions are not outspoken, and so they have no cohesive power. And then I come to my conclusions and prospects for future research. Conclusions are first that subnational autonomy is not inherent to a federal system as federal theory would have it. It's not a defining feature. Instead, it is an indicator, one of many indicators of subnational autonomy and cohesion. And it does not stand on its own. It has to be combined with other indicators, because otherwise we don't get any insight in what balance the system actually seeks between autonomy and cohesion. Now, some questions remain open. First, once we have a clear view on the institutional design, we can see a difference between the institutional setup, that is the constitutional space or the potential on the one hand, and practice on the other. How do subnational entities use their space? Some hardly use it at all. Others take it to the edge. Which factors explain these differences? Second, when we compare systems, we see variations in the scores on autonomy and cohesion. I gave some examples, but also in the combination thereof. What explains these variations? It should have to do with the constitutional choice for a certain balance, with more focus on autonomy, on cohesion, or of the combination of both. But which factors make that a system opts for one balance over the other? One hypothesis, in any case, is that origins are important. If subnational constitutions were pre-existent, then subnational constitutional autonomy will be strong. And then there are dynamics over time. The institutional setup may change. For example, in Belgium, the subnational entities gradually got more powers, not so much, but some more powers, and especially the two smaller entities caught up with the others. What explains these changes over time? And then lastly, even if a system has subnational entities with strong powers to adopt their own subnational constitutions, this does not mean that these constitutions are very important. For example, in many systems, including the United States, we find that subnational constitutions are not very visible and of little relevance in constitutional narratives. And still, in some systems, especially in divided states, they are considered dangerous. No, you cannot have your own subnational constitution because it's a dangerous thing. Why is that so? Why do they have this symbolic value where they're not present and not at all in systems where they are taken for granted? So what is the significance of subnational constitutions and which factors explain that? Now, that's a lot of food for future reflection and research. I'm happy to see that the interest in subnational constitutions is on the rise, and especially in Brazil, and I feel honored that you make me part of that. Thank you.
Thank you very much, Professor Patricia. It's an honor to us to have your participation in our seminar. Your speak is excellent, it's very interesting. It will dialogue with several others speaks, like Giacomo Deledone, like Maria Esther Seijas Villadangos, from University of León, Spain, that will aboard the question of subnational constitutions in regional or unitarian states. Thank you very much. We were pleased with your participation.
It was a pleasure. Thank you.
Thank you, Professor.